So we're going to shift things around a little bit right now because thankfully, and we appreciate it, David LAMETTI, our Attorney General, Justice Minister federally, said we can chat today, but it has to be right now. He has other things. He's committed. And I want to be, first of all, thank him for being gracious. And second of all, yes, that's what we're going to do. And we'll come back and talk about this later. And I believe he's on the line. Mr. LAMETTI, are you there?
Yeah, good afternoon.
Thank you so much for making the time. We very much appreciate it.
Oh, it's a pleasure.
Let me start by reading this. The headline that says, I'm quoting, Ottawa finally decides to stand up to Francois Legault. This, of course, in the wake of comments made by yourself and the Prime Minister yesterday relating to Bills 21 and 96. And while that breaks the long silence, and people have asked why is it taken so long by the federal government over these issues, I didn't hear in your comments yesterday an actual action plan. So what is it you will be doing?
Well, as I said yesterday, we announced publicly, I announced publicly first and then the Prime Minister that if the Bill 21 litigation gets to the Supreme Court, once it's been ruled on by the Quebec Court of Appeal, that we will be there. It will be de facto a national issue, and we will be there to make arguments generally, but in particular about the preemptive use of the notwithstanding clause.
So, go ahead.
No, that's right.
Okay,
and then with respect to Bill 96, it's still wait and see. And I have said this to both of you before, but it will depend on how that legislation is implemented as to whether it offends anything within federal jurisdiction, any language rights and courts and that sort of thing. The devil will be in the details, but we'll watch that vigilantly, and we will defend federal jurisdiction as well as charter rights, and we have the same concerns about the preemptive use of the notwithstanding clause. In fact, it was used quite widely in Bill 96 to cover a variety of different things that fall potentially under provincial jurisdiction, but also fall under federal jurisdiction or infringe upon rights. And so we'll watch that carefully, but we're there to defend the Constitution. We're there to defend federal jurisdiction. And we will continue. We'll have a consistent position with that regard.
Okay, I have two questions. Number one, with respect to implementation, I know you said that many times yesterday. What does that actually mean? Implementation? How do you have to wait for a court case to somehow come up during one of these bills? I'm challenging the bill. What does it mean?
Well, I think we need to see the facts. For example, I'm watching carefully the court system. I can't tell my provincial counterpart how to appoint judges in the court of Quebec. However, if the manner in which those judges are named has an impact on the ability of an Anglophone to get a hearing in English, that will be a violation of Section 133 of the Charter, the Constitution. Now, there is flexibility in terms of how the province names its provincial court judges, and they will, as I do constantly with courts across Canada, try to ensure that there are enough judges who can hear cases in French with respect to particular jurisdictions as well as the federal court. So it depends on that. Same thing with the translation requirement with respect to decisions. If that is something that impedes the ability of Anglophones to get access to justice in English in the justice system, then I'll react. For the time being, I've got to see how that's implemented, and I've got to see whether it does have an impact or not, and make an assessment there. So that's what I mean by watching how, same thing with the search and seizure provision. There are ways, and we do this all the time at the federal level. A number of different agencies have search and seizure powers. There are ways to do it that are compliant with the Charter. There are also ways to do it that are not compliant with the Charter, and so we'll have to watch carefully to see. And as I said, we will be vigilant about protecting the rights of Canadians.
Minister LAMETTI, I don't need to tell you, I'm certain you're well aware of the fact that there is a sense among Quebec Anglos that the federal government has let us down. And now with this announcement, yes, there's some relief, but it kind of still feels like a little too late. Why was action not made earlier? Why was nothing said in a stronger fashion earlier?
Well, I don't think that characterization is fair. I have said from the beginning, in fact, I said to both of you that I would defend areas of federal jurisdiction, but that got lost. Remember, we have a Constitution. I have to act within the powers of that Constitution. I don't have the power to disallow provincial law, so I have to work within the parameters of that. Mm-hmm. And I said that from the beginning. Now, the message got lost. But we're making sure that that message is clear now. The other thing that has to happen is in order to be successful in a court, you need to let cases develop. And while I appreciate not everybody wants to be as patient, sometimes you have to be in order to be successful. And so I am performing my role diligently with an eye to winning, and I'm going to continue to do that.
I have a question with respect to timing. You know, coincidental or not, a day after Bill 96 passes in Quebec, that silence that we've had from the federal government that Natasha just described suddenly broke, and both the Prime Minister came out and made comments. Was that coincidence? Why yesterday?
Well, it was important for us to let the legislative process for Bill 96 run its way through. There are political parties in Quebec who were opposing that piece of legislation. They needed to be able to air their grievances, and the committee process, the legislative process through readings in the National Assembly. We needed to let that run. We don't want to be seen to be interfering with that process. Now the legislation has passed. We will be vigilant with respect to how that legislation is implemented. We will watch carefully for any violations of federal jurisdiction or any rights violations, and we will assess carefully any moves that we make moving forward.
Well, I'm sure you heard what François Legault said yesterday, and reacting to this as well. You just made the point you don't want to interfere in provincial politics, which is exactly what he accused you of doing.
Well, the idea that seeking, that we would be present at the Supreme Court of Canada for a case once it got there. I mean, Mr. Legault takes our federal laws to court over what he feels are jurisdictional overreaches all the time. Luckily, he tends to lose. He lost on carbon pricing at the Supreme Court of Canada. He lost on Bill C-92, which was the ability for the inherent right of Indigenous people to take care of their own children. He lost 5-0 at the Quebec Court of Appeal on a reference. And now he's appealing that to the Supreme Court of Canada. We're pretty confident there. But, this is the idea that one level of government passes a piece of legislation which may have an impact on another level of government. That's been happening since the beginning of Canada in 1867, and it's common to have federal government challenge aspects of provincial laws, and the provincial governments to challenge aspects of federal laws. The idea that we're interfering by virtue of trying to protect the rights of Canadians in the judicial system is quite frankly absurd.
Minister Lametti, can I ask you to comment on the use, or what I would refer to as the abuse, of the notwithstanding clause by the CAQ?
Well, I've said from the beginning, and the Prime Minister said from the beginning, that we have serious concerns about the preemptive use of the notwithstanding clause. I remember the debates when it was added during the constitutional negotiations of the early 1980s, and it was meant to be the last word. It was meant to be the last word to a legislature after back and forth with the courts, and effectively in dialogue with the courts. And it was meant to be a safety valve giving the legislature the last say. It wasn't meant to be the first word. And when you use it preemptively, it is the first word. It ends up curtailing political debate. But as we saw in the Bill 21 case in the decision of the Superior Court Judge, Blanchard, it also curtails judicial review, especially when the Attorney General of the province of Quebec, in this case, says he doesn't even have to tender evidence of why the decisions were being made or the proof of the decision. And so the judge noted that was a lacuna that he had to deal with. And so it curtails political debate, it curtails judicial review, and it undermines the structure of the Charter. Like, we have a Charter that has enumerated rights. Then we have a balancing provision, Article 1 of the Charter, that says limitations might be justified in a free and democratic society. That's step 2. If you say that you can use the notwithstanding clause preemptively, you can skip step 1 and step 2. And that goes against the very structure of how the Charter was conceived and how it ought to apply to the rights of Canadians. And I would also note that they're also using it to apply to the Quebec Charter as well. And so this is, I think, something that's very bad for Canadian democracy.
Okay. Minister LaMetti, we want to thank you for your time. Very much appreciate it this afternoon. Thanks so much.
Thank you.